Reasons why Parliament arson accused Zandile Mafe has for a second time not showed up in court. We have on the line Zandile Mafe's lawyer, Luvuyo Godla. Very good evening to you. Hopefully the line is good this time around. Your client Zandile Mafe has for a second time refused to appear at the Western Cape High Court. I know the last time he failed to appear, it had to do with a hunger strike. Were you aware that he wasn't going to be in court this morning?
I was not aware that he was not going to come to court today. However, I was advised early in the morning, only today, that he refused to come out of his cell and come to court. So I then advised the court some of the reasons which I am assuming is because we have been engaging Pollsmoor authorities to allow him to get radio, to get TV, to get cable, which is yesterday it was decided that cable cannot be allowed because it's used as one of the weapons to burn each other. So it will not be allowed. So Mr. Mafe must accept it. I did not have time to advise him about that decision yesterday. I only assume that such a decision must have been communicated to him. Hence, he is retaliating by not coming to court because he has been complaining that the treatment he is getting is very appalling, is not the same as the treatment which is given to other South African citizens. So I will go and consult with him next week with the leader of our team, Advocate Mbofu SC. And the Junior Counsel, Niki Wenyat. We will know with great certainty the reasons why he did not appear today in court.
So you say that he says that he believes he may be treated unfairly when it comes to some of the conditions in prison. What does this now mean for the actual case? What sort of precedent does it set going forward? Because the state has also shared that 95 of their case has been only shared with the defense.
In fact, what we will advise Mr. Mafe, we will advise him about the implications of his conduct now currently. But I just wanted to warn members of the public, his failure to appear in court might be something correct to raise a concern. In fact, it's correct to raise whatever dissatisfaction one has. But now, to refuse going to court, it borders around contempt of court. And it jeopardizes his chances of getting bail. Because a question that everyone will have is whether will he be able to come to court if he is released on bail. If he is not coming to court successfully while he is in custody. Obviously, it's a question, it's a legitimate concern that everyone might have. But it does not automatically suggest that he is in contempt of court. He does not know the implications of what he is doing. We are now to advise him and we want him to desist from that particular conduct.
Yeah. I know that questions have been again raised in court about Mr. Mafe's mental state. Has the state made efforts to seek a second medical opinion? Because previously the prosecutor had said that the first one was not satisfactory, the one that was done with Magistrate Mbalo.
Yeah, they cannot raise that. Remember, they cannot simply raise that. There ought to be a fair procedure to arrive to that determination. Yes, Section 78 might be brought by any party, even though ordinarily it's the defense that raises that Section 78. However, looking at the linguistic meaning of the Act, any party can raise it, but bear in mind that the one who brings that application, who invokes provisions of the Act, Section 78, bears the onus of proving in court that indeed this person is not mentally able to understand the proceedings. Even if it can transpire that he is not able to appreciate and he is not fit mentally, but we need not to come up just all of a sudden, make a very big jump. We need to follow a due process. There ought to be some issues that shed light to a reasoning that this person might not be medically fit. Now, mere refusal to come because he demonstrates and he shows his dissatisfaction cannot amount to suspicion, a reasonable suspicion that this person is not mentally fit. Yes. We first need to advise him about the implications of what he's doing. Then we can take it from there. All the parties, we did not have any issue other than saying, let us follow the correct procedure. You can't simply disagree with a person and you come up and you say the person is not mentally fit. It was worse in his case because nothing was said, nothing, absolutely nothing, not even greeting him. It was a question that he appeared before court and he did not comb his hair, and then the court assumed that this person must have been someone who is not mentally fit. And the doctor did not have the prerequisite hours within which to observe this person and come up with that suggestion. Mm-hmm. So that was the reason. It might be he is not fit, but it's not the right time to come, and we don't have information to have that suspicion for now.
Absolutely. Now, the state had previously said that it's ready to proceed with the matter and that the defense is not ready. Would you still say that's roundabout accurate?
No, they cannot say that if they were ready. They placed us in possession of further particulars. I think it was 50% on the 12th, and in court on record they said, we will place defense in possession of further particulars by the time when we come here on the 2nd of September. Surely the defense would have been in possession of further particulars. Then we were placed only last week on Thursday. Remember, when you get further particulars, you must go through further particulars, and you must go and consult a client, knowing quite very well what is contained, what is the case of the state. So, when we were placed only last week, we need to meet as a team. We go through everything, we meet, then we consult with him, and we know our case. And it's still far from being ready. They are not ready as well, because we still need to meet and come up with issues of common cause, where we will come up and draft admissions. For example, we know as a matter of fact that Parliament was burned down. And we know as a matter of fact that Mr. Mafe was arrested within a certain proximity. We know as well that the extent of damages in the Parliament are very huge. We don't need those witnesses that must come and lead the evidence, formal evidence about the gravity of the damages in Parliament. Hence, we still need to meet. No one can simply go to court and say we run. We need to agree on those issues, and we know exactly we zoom only to the relevant issues for court's determination.
Very well. We're going to have to leave it there for now, and thank you for your time. Zandile Mafe's lawyer, Luvuyo Godla, speaking to the merits of the case and, of course, some clarity on why his client didn't show up in court today.